Hello, everyone. Um, I selected the chapter on bankruptcy for my presentation. Um, the Merriam-Webster Dictionary defines bankruptcy as the status of a debtor who has been declared by the judicial process to be unable to pay his or her debt. The Bankruptcy Act and its goals are what I'm gonna be talking about. I'm gonna be mainly focusing on the Bankruptcy Act and its goals, why it was set up, and then we'll also briefly talk about the other, like the four types of types of bankruptcies that individuals and corporations can take advantage of, like which is a liquidation, reorganization, debt for a family farmer, and debt adjustment for regular individual with regular income. But I'm not gonna spend a lot of time on the others. I'm gonna mainly focus on reorganization and under Chapter 11 bankruptcy. The Bankruptcy Act and its goals. The first goal is bankruptcy laws provide protection to creditors, entities to which a debtor owes money. Bankruptcy laws ensure that creditors competing for debtors' assets are treated equally and receive a fair share of the debtor's assets. Second, bankruptcy laws provide opportunities for debtors to gain a fresh financial start. Uh, this is just in brief. It just tells us that, like, the bankruptcy laws were just created to benefit mainly the creditors more so than the debtors. Um, in a way, it ensures that, like, the creditors get, like, as fair a deal as possible, since, like, the creditor is unable to pay the debt. So whatever is left of the company or the individual's assets can be divided equally among the creditors, and also gives, like, people and businesses a chance to make a fresh start after they've messed up financially. Um, as we learned in our text, dynamic business law, uh, Congress first addressed bankruptcy relief in the Bankruptcy Act of 1898, and it has been amended five times, the last being in 2005. The United States Bankruptcy Code makes four types of relief available to bankrupt individuals or corporations. The first one being liquidation, which falls under Chapter 7, reorganization, which falls under Chapter 11, debt adjustment for family farmer, which falls under Chapter 12, and debt adjustment for a regular individual with regular income, which falls under Chapter 13. The court determines which debts are to be paid, and the debtor is typically granted a discharge of the rest. We read in chapter 3 that, like, the federal court system is the one that has jurisdiction over all bankruptcy cases. Reorganization under Chapter 11. Generally, the creditors and debtors agree that part of the debt will be discharged while the other part will be paid. A quote from the book from Dynamic Business Law goes, creditors generally agree to these plans because they believe that the value of the operating business is greater than the value of the business broken up and sold in pieces. Uh, in this case, we can use the example that was used like in the textbook. It was mentioned briefly in the beginning of the bankruptcy chapter. It talked about General Motors that was going out of business and filing for Chapter 11. In a case like that one, the creditors were better off with General Motors staying in business and continuing to make cars and sell cars than for General Motors to go out of business. A case in point is an example I'm going to give you is of Delphi. Delphi is a company that makes auto parts for most of these, especially mainly for the big three, Ford, Chrysler, and GM. But their biggest customer is General Motors. And if General Motors had filed for bankruptcy and had not been able to continue conducting business as they are now, that would have just affected General Motors and its customers and employees, but it would have also affected the suppliers like Goodyear, Firestone, the tire companies, and also Delphi that makes like a lot of these auto parts that are used for spare parts, and it also for parts for new automobiles. So, in talking about Chapter 11, General Motors as well as Chrysler filed for bankruptcy protection. Both companies filed for Chapter 11 bankruptcy protection in 2009, and then both companies received tens of billions in taxpayer dollars uh, to help them pay some of their bills and to continue operations in their factories. I mean, this was a very, very controversial decision that was done by the government. Some people liked it and others didn't like it at all. One of the people who didn't like it is David Skill. David Skill is a professor of law at the University of Pennsylvania. He wrote an article that appeared in the Wall Street Journal in June 6, 2011. The title of the article was "The Real Cost of the Auto Bailout." The government's unnecessary disruption of the bankruptcy laws will do long term damage to the economy, is what one of his paragraphs read. Mm. He continued to say rather than undergo a restructuring under ordinary bankruptcy rules, however, each corporation pretended to sell its assets to a new entity that was set up for the purposes of the sale. He concludes his article by giving like uh, an example that I personally didn't know about. I did read about it in this chapter. It talks about the victims of the defective GM and Chrysler cars waiting to be paid damages weren't so fortunate. They'll end up getting nothing or next to nothing. In this case, he's talking. The author, in this article, is talking about the customers who are the buyers, the people who drive these cars that are made by GM. GM makes a lot of cars with different name brands: Chevrolet, GMC, Cadillac, Buick, and stuff. And then Chrysler makes Dodge, Jeep, and of course Chrysler too. So if you were driving one of those nameplate cars that were made before the two auto companies filed for bankruptcy, and something happened to you, like an accident or some defect on the car that ended up with you getting injured or something. If you were to try to file like a claim, GM and Chrysler uh, can avoid like responsibility for that, because they can hide behind the fact that like that was the old GM, that's the old Chrysler. So the federal laws and the federal bankruptcy code allows them to do that. So you can go ahead and sue, but then you'll be in line with all the other creditors who are waiting for their money. So you might get a little bit, or you might never get anything at all, in settlement. So he tells us that GM and Chrysler have successfully argued that they are not required to take responsibility under the federal bankruptcy code. The new Chrysler and new GM are not responsible for one, pending lawsuits against all Chrysler and all GM. Two, any damages awarded to drivers who previous one sued against the oil companies and had not collected the money. And three, lawsuits by drivers who got into accidents during the bankruptcy. So I think the one that stood out the most was, to me at least, was where he says there are any damages awarded to drivers who previously won a suit against the oil companies and had not collected the money. So if you had sued like Chrysler and GM before 2008 and you won your case, and let's suppose you were just waiting for them to cut you a check and then they file for bankruptcy, they don't have to pay you the money anymore, which I personally believe is very very unfair. Mm. And I think like the federal bankruptcy code should be changed in some ways to like protect people like that. Like, I think if you won your case in court over some defect that the company had caused, you should be paid your money. Like GM and Chrysler, they should have used like all those billions that they got from the taxpayers to take care of their creditors, and then also take care of these pending lawsuits, like, and future lawsuits again. Because if the defect was caused by these automakers because of a fault, a flaw in design, then they owe their customers the money and they should be made to pay it. Thank you. I'm done.